must have business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to oral argument session here at the 5th District Court. As Marshall said, I am Judge John Harris, joined on the panel today by Judge Brian Lambert and Judge Joe Boatwright. We've got 3 more cases today on the docket. Each side has 20 minutes to present their argument. Appellate can reserve as much of that 20 minutes as you would like. The default is 5 minutes. If you would like something other than that, please just let me know. If you have any cell phones or other noise-making devices on you, please make sure those are silenced at this time so the proceedings are not interrupted. And just a reminder that the hearings today are being recorded and live streamed on YouTube. All right, our next case is 23-459 State Farm versus McClendon. Counsel for appellant, if you are ready, you may proceed.
Good morning. May it please the court. My name is Ryan Jones and I represent State Farm Florida Insurance Company. I'll reserve the standard 5 minutes for rebuttal if that pleases the court.
Thank you.
I think the court's aware that we have this same issue on appeal in a handful of different cases. I want to start today by addressing an issue that wasn't quite as clear as it could have been in some of the other arguments. That is, a decision in favor of State Farm does not preclude the insured from recovering the tear-out costs. All the insured would have to do is enter into a contract that satisfies the requirements of the policy and Florida law. And that's what State Farm is requesting in this appeal today.
Why does the contract here not satisfy State Farm?
The contract doesn't satisfy it because the requirement under the policy is that the cost must actually be incurred before the payment is due. And I'm getting that from the Florida Supreme Court's Zavallo decision. The contract in our case has a clause that allows the insured to void the contract up until the point that State Farm's
But only if the insured doesn't pay, correct?
Only if the insurance company doesn't pay.
Oh, sorry, the insurance company doesn't pay. So really State Farm has the ability to control that contract then, correct?
I'd say that State Farm has the ability to control the check, Your Honor, but the actual control of the contract is done by APT. That's who wrote the contract. So if APT did not want that, what I'll call a contingency in there, it simply could have written the contract differently to not include that. The reason that's such a concern is that up until the point that State Farm issues the payment, the insured has the ability to void the contract, essentially to escape liability. And under Florida law, the point at which liability attaches is the point at which an expense is considered incurred.
Why does State Farm care what Miss McClendon does with the money? I mean, it's a covered claim. You went through the appraisal. You guys compelled the appraisal. The appraiser came back and said this. Miss McClendon said, good number, or she said, well, that's the number, and there we go. And you guys said that's fine. If Miss McClendon goes and spends the money on lottery tickets or fixes the place up or does, pays for her kids' college, what does that matter to State Farm? At this point, she's paid premiums all these years or whatever.
Under the base coverage of the policy, Your Honor, there is not a restriction on how the insured spends the money, and that's the coverage for the direct physical loss. But the coverage that we're dealing with, tear-out coverage, is an additional coverage. It's something, as the Florida Supreme Court described it, above and beyond the base coverage. And what's important about it is that the language of that additional policy, of the additional coverage, says that it is a cost incurred by the insured. And the whole purpose behind that is to ensure that the work is actually done, as opposed to the insured saving it or buying lottery tickets or using it for any other purpose they choose.
I'm not suggesting she would do any of those. That was just a hypothetical.
Oh, certainly, Your Honor. And it is just that's the reason for that type of a provision, is to ensure that the property is repaired.
So what's your interpretation of when you actually incur the costs? When does that happen?
Judge, that was addressed in the second DCA's Boer decision, and what the case states is that when liability attaches, that's when a cost is incurred. And
so what do you mean by that?
When liability attaches, when there's nothing else to be done in the contract. And Boer provides a real good example of that.
So when So when she pays for those costs?
She could do it a number of different ways, I believe, if the work begins or if she writes the check for the cost. But the contract...
Why not
itself-
just specify that in the provision clearly then?
Well, the provision I'd submit, Your Honor, does specify clearly that the cost must be incurred. It's Florida law that interprets that phrase incurred to mean become liable for. And at the point which liability attaches, I think it's a fair reading of that case law to say the point at which liability attaches means there are no more contingencies left in the contract. There's no escape clause or out, for lack of a better word, for the insured. And that's why the APT contract...
So are you talking about the Sabalo case?
The Sabalo case is the one that defines incurred. The Boer case is the one that says liability attached.
Well, doesn't Sabalo, towards the end of the case, it says Citizens Counsel conceded an oral argument that to incur means to become liable for the expense, but not necessarily to have actually expended it, and then the Supreme Court said we agree.
Correct.
So she wouldn't have to actually pay for it under the Supreme Court's ruling in that case, correct?
That's exactly right.
Okay, but you had just told me before you mean incur means to have to pay. That's one of the things you look for is whether they paid it or not.
If I use the word payment, I must have misspoke, Your Honor, and I apologize. The incurring is to become liable for. The point at which liability attaches is when the expense is incurred. And in this case, our position is that liability has not yet attached because under the APT contract, the insured can still void it up to the point that State Farm issues the payment. So as we stand here right now today, State Farm has not issued the payment, and if this court finds in favor of State Farm, the insured would not be liable to APT because she has the option to void the contract.
So what would she have to do? Okay, let's say it was $120,000 instead of $12,000. And let's say she, like most people, doesn't have $120,000 to just pay it out of pocket. She would have to enter in a contract with APT saying, I contract with you to go do this repair work and I'll pay you $120,000, end of discussion, and then they show up and start working. I'm trying to envision what it is other than her actually, here's your money,
So
how it becomes incurred under State Farm's view of the policy.
she would have to enter into a contract that imposes liability. And what I mean by imposes liability is there is no escape. There's no escaping the contract. In this case, the insured can void it. If that were removed, and we had, for example, the contract that said, we will do the $20,000 in tear-out work, period, and that were signed, that would impose liability.
Again, isn't the escape clause, though, that the insurance company won't pay for it, correct?
The escape clause allows her to void it if there is no coverage or no payment. And that is how the insured escapes liability. And so I'd submit to the court that liability cannot be considered to have attached if there's still a way to avoid liability.
So I guess I'm still trying to figure out what your answer is. So if they said, okay, I've just listened to all those people over in Daytona Beach today, you, Ms. McClendon, APT, will say, here's a contract. One, I agree to pay you $12,000, whatever number. You agree to do this tear-out work that's defined in the appraisal award, dated, September 21, 2023, and says, here you go, State Farm. So I guess in theory, and if she then didn't allow them to do that work, she barred them from coming in the door, and they sued her, even though they haven't performed the work yet, that would be, State Farm would pay under that? That's an enforceable contract, or that's a contract of which she's liable under? Is that what you're saying?
If those were the terms of the contract that Your Honor
Those are
just
my
outlined,
contract terms here. I'm trying to figure out, okay, they shouldn't pay it. What is it that State Farm is going to require her or any insured in this scenario to do, in State Farm's view, to have a valid contract? Because, I mean, at the end of the day, if she signed the contract that I just hypothetically set forth, I guess she could just say, I've changed my mind, I'm not letting you in. Is that company, I'm envisioning State Farm would say, well, then they have to then sue her, and then they have to get a judgment. Now she's, quote, liable there, and then we'll give you the money. Is that, am I walking the scenario through correctly?
I understand your hypothetical now, Judge. Thank you for clarifying. So in your hypothetical, the contract terms that you've outlined would impose liability on the insured. Once that contract is provided to State Farm, the payment would be issued because
Okay.
liability would attach. The next step of Your Honor's
Well,
hypothetical.
let me then, and I'm not suggesting deviousness on behalf of Ms. McClendon or anybody similarly situated, but so, okay, she gives you the contract you guys are happy with, you write her the check for $12,000, what have you, then she goes buys the lottery tickets, and APT goes away. You guys are saying, hey, policy language was met, that's a fight between APT and McClendon, assuming there wasn't some, quote, fraudulent behavior between the two of them.
Right,
Then you guys, well, closed file, go to the next one.
Assuming there's no fraudulent behavior or intent to deceive or anything along those lines, any dispute that arises after that point
Yeah.
between Ms. McClendon and APT is between those two.
Let me make it more altruistic on Ms. McClendon's point. She gets the check and she finds out that her child is in serious health issues and she needs to spend that money to help the child. And she says, you know, that was really nice at State Farm, but between fixing my what have you, or giving, you know, providing the hospital expenses or paying the bills for my 19-year-old son, that's the route I had to go. I apologize, but that's how it turned out. Sorry, Mr. APT. And APT says, boy, I hope your son's doing well. Have a nice day. I should have been a law professor listening to this. But, I mean, in that scenario, then I'm just trying to envision, you know, what the parameters. I mean, what it really is going to tell the parameters of what you guys are saying is a valid contract. Under that scenario where I've added that, you've gotten in your mind, you guys have gotten a valid contract. You've paid the money. Whether APT or whatever chooses to enforce it when she had to go spend the money for the medical expenses for her adult son, that's between APT and your homeowner or your insured. You guys have complied with the policy and you've got no more beef with her.
Unfortunately, Your Honor, I really can't speak to what happens between APT and the insured after the fact, because that is in fact
Well, that's what I've
between
told you the
those two
facts are,
parties.
as I find as a trial judge.
Correct. So State Farm really can't address what happens between those two and any agreements they make or any breach of that contract that may or may not exist.
But they've gotten a valid contract. In State Farm's mind at that point, it looks like she's liable to APT. Whether down the road APT just bites the bullet and says, unusual circumstances, we're not going to pursue it. We know she got the State Farm money to pay us, but, you know, we're doing our good deed for the year. And I'm not maligning APT. I don't know who they are, but
Certainly. In that situation, the terms of the contract that Your Honor outlined would be the ones that
that's an
control.
incurred expense under the policy.
That is an incurred expense under the contract. What happens after the fact, obviously there are hundreds of different scenarios that could arise, and I guess that would have to be addressed on an individual set of circumstances after the fact. But in all of those hypotheticals that Your Honor and I just went through, the key is that there was a contract that imposed liability and then a payment was made. All of the other scenarios that happen after the fact, we can address those as the facts may warrant. But the critical distinction between the contract Your Honor was talking about and the contract that we have in this case is that there was not an escape in Your Honor's hypothetical contract. Here, there is an escape that allows the insured to get away from liability. So that still remains to be imposed. It hasn't attached, as the Boer case says.
So there's an appraisal award in this case, correct?
There is, Your Honor.
Okay, so why does the lost payment provision not apply?
Because the lost payment provision is the general provision of the policy. The case law is developed in such a way that if there is a more specific provision, then that provision controls when payment is due. And that's the more specific provision we're relying on in this case is the cost you incur provision.
You would agree, though, in the lost payment provision, it talks about the appraisal award, correct?
It does,
And then
Your Honor.
paying it within 60 days after the proof of loss?
It does, Your Honor.
Okay.
And
So you're saying, is that referenced anywhere in the tear-out clause?
It is
That the
not.
lost payment provision does not apply?
It does not specifically say that in the tear-out clause. But I don't think that prevents a barrier to the payment. And the best case I can think of to exemplify that is the Everhart versus Citizens case from the first DCA. And in Everhart, there was an appraisal award that included an amount for ordinance and law. And ordinance and law has the same cost you incur language as the tear-out provision. And the ordinance and law provision, just like tear-out, doesn't reference the lost payment. And what it was actually a concurrence that said it. It was a very short opinion with a concurrence that explained a little more. What the concurrence in Everhart said is that the insured had not incurred that amount for ordinance and law identified in the appraisal award yet. So the payment wasn't due yet. And I'd submit that's the same analysis that applies in this particular case. And we've cited a number of cases in our brief that explain when you have an appraisal award, that doesn't alter the other terms of the contract. It simply sets the amount of the loss and allows the parties to apply the other terms of the contract. And so in this case, the tear-out provision with the incurred requirement is still applicable. And unless the court has any specific questions for me, I see that I'm getting very close to my rebuttal time, so I will save the remainder.
Okay, thank you, sir.
Good morning, Mark Nation on behalf of the appellee. Counsel and I were just in Jacksonville about 60 days ago.
For him?
Yep.
Okay.
In the 5th DCA, which was hard to get used to, and having this argument. So it's been almost 60 days. I asked them to write an opinion based on the questions being asked similar today. We haven't gotten an opinion. Judge Maker, Judge Soud, and Judge Jay were on that panel.
All right.
And so I just want you to know it seems like they're probably working on a written opinion on this issue. We've also argued in the 2nd DCA.
So they haven't ruled yet, and they
have
had a
not.
couple months ago? All right.
Yeah, and the 2nd DCA just issued a PCA on this issue. Same counsel, same arguments, same issues.
In your favor?
In my favor. All right. And so I'll just address a couple of the questions. As far as Sabello is concerned, as we think about Sabello, there was no breach in Sabello. They paid the policy limits in that case, and then the insured wanted coverage for law and ordinance. And what the Supreme Court said in that circumstance is, wait a minute, go start the work, and then if you actually have those expenses for law and ordinance, which is additional costs which you incur as a result of upgrades for code, then submit that claim. On the last page, it talks about the definition that the Claimants Council, I think it was, Citizens Council agreed to. What Judge Jay said in the oral argument that we had, and he came out right out at the top, is that's not the only definition of incur. There are lots of definitions of incur. And the definition he wanted to talk about was to suffer. Black's Law Dictionary says incur means to suffer. Here, Ms. McClendon has suffered a loss. And I do want to contrast tear out with law and ordinance, because the cases they rely on are law and ordinance, and Sabello is, again, no breach. Here we have a breach. There was a breach of contract. The appraisers awarded more money. And tear out is money to access the thing that caused the loss. Very different than law and ordinance. It's a different type of coverage. And it doesn't make sense that State Farm would pay for the water damage and say, here's your money for your water damage. Go do that. But we won't pay for the thing that caused it. Even though the loss payment provision is triggered, we won't pay for the thing that caused it unless you enter into a contract which we approve. Now, that just doesn't make any sense logically that they would hold back the payment on the thing that caused the loss, nor are they allowed to address, the case law cited in my brief talks about a third party to a contract, even an insurance company whose payment is dependent upon it, can't come and attack a contract and say it's not enforceable. And this contract is clearly enforceable. They are using judicious use of ellipsis to say it's voidable at any time. It's not. It's only voidable, and I've set forth all of the criteria, and there are about 5 of them, if those 5 things occur, none of which have happened in this case. For that provision for voidability to apply, there has to have been the insurance company has no liability. They don't owe anything. Here, they're required to pay. And if you look at what their argument is this, according to them, this contract is only enforceable if we pay, and we're not going to pay because the contract's not enforceable. It's just a circle. The provision that they're relying on isn't the provision that applied in this case. It's the second one. And on the contract, it says, if my client is paid less than the full amount, we agree to negotiate scope. And they're withholding the payment so that can't happen. So I really don't want to belabor the point. I suspect the other panel is writing on it, but if I can get a written opinion on this, it'd be very helpful, because this is happen in a lot of circuit courts, in my cases, throughout the state. Nothing further. Thank you.
Okay. Thank you, Mr. Nation. All right, just over 6 minutes.
Thank you, Your Honor. I'll address 3 points that Mr. Nation brought up. The first is Mr. Nation argued that a third party to a contract cannot attack the validity of the contract. And I think this was clear in our briefs, but I want to make sure that we're real clear on this. We're not attacking the validity of the contract. The issue we have with the contract is, as I mentioned before, that there is still an escape clause, which means that liability has not attached yet, and that's the requirement for incurring a cost under the policy. The second issue that I want to address is counsel's comments about the other argument before this court, and specifically Judge Jay's question with respect to the definition of incur. And Black's Law Dictionary does define incur as to suffer or bring on oneself a liability or expense. I think it's really important when we start dealing with that definition to recognize the distinction between damage and the cost to repair the damage. The damage here has occurred, so it's very easy to say that the insured has suffered the damage. But that is not the same thing as incurring the cost to repair the damage. And that's the provision of the policy that's at issue, the cost you incur. So if we are suffering a cost, incurring a cost, becoming liable for a cost, all of that, again, the same thing, recognizes an obligation for the cost. It is not the existence of damage. And we have to focus on that obligation to pay the cost, which is what we've talked about in the initial argument. The final point that I want to bring up, Mr. Nation mentioned that the argument is essentially circular based on the provision of the APT contract. And I'd submit to the court that it's not a circular argument. What the APT contract does is try to work backwards from what the policy requires. The policy, again, the language, the cost you incur. The Sabalo case states that unambiguously requires the insured to incur the expense before payment is due. So under that language, it is incurring the expense first, payment second. When we look at the APT contract, it has an escape clause up to the point that State Farm issues payment. So essentially, it requires payment first and then liability attaching second. So it's actually the opposite of the way that the policy should work. And again, all we're asking for is to apply the plain language of the policy and have a contract that satisfies that requirement, that liability for the cost of tear out is imposed on the insured without an escape or another out, for lack of a better word. Once that is presented, State Farm will issue the payment. And that's what we're asking for, and we believe that's the decision the trial court should have reached. So we're asking this court to reverse and remand with those instructions. Now, unless the court has any other questions for me, we'll rest on our briefs.
Okay, thank you, sir. Thank you both for a very well-argued, well-briefed case.